Yes.
137.
Yes. Please don't mention for fixing on the very first day. Let us see how it goes. There are so many matters on the list. Let us see. Sorry, not immediately.
91 and 92 of today's list, Miller, two appeals arising out of the same order, 92 and 93.
Yes.
Miller, the matter is extremely urgent, Miller, because in the interregnum, during the Puja vacation, Miller, an order has been passed stopping my commercial establishment, which was my only source of livelihood.
I'm sure there are other matters which are equally important, sir. So let us see. Allow us to proceed. Allow us to proceed. For listing? Yes. For inclusion? Give it. Inclusion? Give it. Give it. Give it.
Your Lordship.
On the list.
Your Lordship, I crave leave to mention a matter, Your Lordship.
Yes.
For inclusion, Your Lordship, bail matter for inclusion.
Yes, where is the number?
CRM NDPS 461 of 2024, Your Lordship.
All right. It will be included.
Grateful, Your Lordship.
Yes.
Item number 1.
To be mentioned. Why to be mentioned? It says defective. Well, Passover today is the first day. Wrongly classified as economic instead of effective. Not today, sir. Not today.
Lordship praying for not today. The conducting report is out of station.
Not today.
Item number 3.
But before she starts, my lord, in this case, actually, we have prepared an SLP before the Supreme Court.
In this case.
So co-accused in connection to this case, actually what happened, one of the co-accused has been granted bail. So against that, we have prepared an SLP before the Honorable Supreme Court. So we have already filed it, it has not been heard. So I have the filing slips and all, so let it be fixed.
No, let us hear what is our commercial quantity. If you succeed in the SLP, the bail will go. If she's claiming it, the co-accused is claiming on the ground of parity. Seizure from joint possession.
Joint possession, the last circuit, same thing was there, the same argument was there regarding, so the last of the judge, Honorable just stated as why you have not preferred the SLP when you are raising objection.
All very well, sir, but today the order stands.
My lord.
Rightly or wrongly? Now, file to now. It's good order to stand, could see. If it is set aside, we will also make an application. Where is that orders? You do not dispute that he stands on the same footing.
No, he is on the same.
So, hey, Yeshu, could you
Still, my objection may be, my lord.
CD is here.
CD on the last occasion.
Anyway, then we will record your submission that
My lord.
he stands on the
My
same
objection is there, but there's a same.
Yeah.
Yes.
Listen to what I say. The petitioner claims parity. Stop. He says that a co-accused person, namely Kobir Bisho, alias Vishwash, was granted bail by a coordinate bench on July 25, 2024, in CRM bracket NDPS 284 of 2024, stop. He says that he stands on the same footing as Kabir Bisho, stop. Paragraph, learned advocate for the state, while opposing the prayer for bail, does not, in his usual fairness, does not dispute that the petitioner is similarly circumstanced as Kabir Bisho, stop. Paragraph, accordingly, hence, on the ground of parity, we allow the petitioner's prayer. Next, accordingly, usual order, accordingly. But got the 25,000, na? 25,000.
My lord, can you, my lord, mention the diary number of the diary of the Supreme Court that already.
Acha, arekta bole daw. Learned advocate for the state, Ukhanta, further states that a special leave petition has been filed by the state against an order passed by a coordinate bench granting bail to Kabir Bisho. Kabir Bisho.
So diary number 46063/2020.
Being diary number, ota diye daw.
46063/2020.
However, as of date, there is no order of stay from the Honorable Supreme Court.
Grateful, my lord.
Item number 4.
How long you are in custody?
He was arrested on 5/4/2024.
5/4.
And he was same duty, another space 12 of my application granted base.
Similar order interim bail দিয়ে report চাই report চেয়েছি report next keep করবে এখানে control দিন দিয়েছে এখানে এই ধরে লিখেছিল order being changes the last date of the next ডেটটা জানি না এরকম ভাবে দিয়ে Mr. Ganguly, we'll pass the same order, similar order. The petitioner claims parity, stop. He says that by an order dated October 1, 2024, passed in CRM NDPS 430 of 2024, a co-accused person was granted interim bail by a coordinate bench.
My was granted interim bail.
Oh, this is your petition.
He was granted interim bail.
Oh, that means
Oh.
it is pending matter.
Oh,
Extension করে দিলে
then what is, তাহলে হবে না, ছেড়ে দাও। Yes, then what is
It may be extended
extended?
because the fate regarding the SLP and other things.
no instructions of
Because on similar issue, the SLP is pending.
What is the issue?
Issue is lordship, why the bail of co-accused was granted?
Forensic report? No.
No lordship. Here, in this case particularly, though they have not pleaded, the FSL report has not been submitted, but the charge sheet was submitted.
We have in
Yes, lordship, I
Calcutta,
have the order. So I am not opening my mouth. I have the order.
confirm করে।
I am not opening my mouth.
We'll confirm the order. Then whatever the Honorable Supreme Court decides, আমরা hold করেছি। Ordering একটা division, জলপাইগুড়ি না কলকাতা চার্জশিটের শুরু যদি FSL রিপোর্ট না ফাইল করা হয়, চার্জশিটের কোনো দরকার নেই। আর তারপরে মাসের দিনের ভিতরে FSL রিপোর্ট নিতে হবে, তাহলে চার্জশিটের মিনিং লাগবে, মিনিং ডেজ আর স্ট্যাটুটরি ডেজ।
The coercion was granted bail, and because we tried to place it that the recovery was joint possession. But honorable court found it that separate recovery was made. So it was divided and paragraph 3, page 12, that below commercial quantity, and so bail was granted.
So on which ground? That is FSL report or that
No, not a
the quantity, quantum,
But you have not applied for statutory bail.
on
No,
merits?
Or minutes, claiming as below commercial quantity, one was granted, I claiming on this ground.
submit, the direction was to submit a report on the legal remembrance.
The report was submitted but the legal members did not submit the report. We have commented this.
Then we'll just extend the bail and put it before the next circuit.
What was
It was called for by the earlier bench, coordinate bench, from the LR. Learned LR will submit a report as to the stand of the state with regard to the prayer for bail of the petitioner when the petitioner stands on the same footing, particularly in view of the same objection not being accepted by the coordinate bench.
Let me explain what it is. Para 12, page 12, para 2 was our submission. That it was a joint position.
Yes.
Now, in this case also, we placed the same footing. So honorable court took the view that earlier this point was not considered the bail. Why are you taking the same point once again? We placed before lordship repeated that in bail, the order of bail is not binding upon it's a decision.
Yes,
So
he has
we
noted
can-
that. Now investigation is complete. Huh? We'll confirm it. Read order dated October, na ki bollam? Achha, read order dated October 1, 2024. Stop. By that order, a coordinate bench had granted interim bail to this petitioner and had called for a report from the learned legal remembrancer. Stop. No such report appears to have been filed. Paragraph. The petitioner claims parity. Stop. He says that a co-accused was granted, correct, Mr. Poddar? A co-accused person was granted bail. Order, where is it? By a coordinate bench on July 24, 2024 in CRM NDPS 295 of 2024. Stop. He says that he stands on the same footing as that person being Jaidev Mohanto. Stop. Paragraph. Learned advocate for the state while opposing the prayer for bail does not, in his usual fairness, you are disputing that he stands on the same footing? No. In his usual fairness, does not dispute that the petitioner is similarly circumstanced as Jaidev Mohanto. Paragraph, hence, on the ground of parity, we allow the petitioner's prayer for bail accordingly. The order, interim bail already granted to the petitioner stands confirmed on the same terms and conditions as recorded in the order dated October 1, 2024. Disposed of.
Item number 5. Matter is similar, my lord. On ground of delay in trial, I am customary 3 years 6 months, my lord. One coaction granted bail on ground of delay in trial, and I am on interim bail, my lord. Then 15 is the order for the coordinate.
You have 3 years. What is the stage?
Is for evidence of the last. All the
I am interim bail, last time I can.
Oh, you obtained interim bail.
Yes, ma'am. Same
Yeah.
6 weeks extension.
We'll extend it. We'll extend it. Where is your order granting interim? In 4th October. Read order dated October 4, 2024. Stop. Paragraph.
No, was that confirmed right from the very beginning? No, your was granted interim bail.
Correct. You will read. Next. The petitioner was granted interim bail by a coordinate bench by the aforesaid order on the ground that he stands on the same footing as a co-accused person who was enlarged on bail on July 29, 2024, passed in CRM NDPS 354 of 2024. Stop. The petitioner seeks confirmation of the interim bail, saying that he is in custody for about 3 years, 6 months. Stop. Paragraph. Learned State Counsel, while opposing the prayer for bail, says that the last prosecution witness is scheduled to be examined today. Today. Stop. Paragraph. The petitioner is in custody for a very long time period. Stop. We cannot lose sight of the fundamental right of an under trial to personal liberty and speedy justice as enshrined in Article 21 of the Constitution of India. Stop. On the ground of lengthy detention of the petitioner, we are inclined to confirm the interim bail that was granted in his favor, and we do so, on the same terms and conditions as recorded in the order dated October 4, 2024. Disposed of.
Section 8C, 21C, 23(1) and 29 of the NDPS. Contraband seized from the petitioner 9 kg gaja and 280 grams of heroin. I'm in custody for 212 days.
Sole accused.
So, Rashid, there are two activities. One is juvenile, was sent to the juvenile. Rashid, what has happened, Rashid? The contraband was seized on 7th of April 2020.
Heroin is over 250 is commercial.
30 grams. 7th of April, the contraband was seized, and thereafter, on 29th of April, after 22 days, it was sent for FSL. The charge sheet was submitted without the FSL.
Charge sheet was submitted within 180 days, but without FSL. Did you apply for statutory bail?
Because before 180 days, they submitted charge sheet.
So how many days you are in custody at present?
200 days.
212 days. Without
There are violations of 13 and 14 of the NDPS.
You should have applied for statutory bail. Commercial quantity. Without a and as good as no action. Kindly practice of it. Because he said that is why it is also going to be plus after that you can put your opponent and it will know you without a Sir, what is, have you obtained the FSL report? Till today, no. Then 212 days in custody.
And as per report, the age of the petitioner is 22 to 25. That is just different.
That is different. That is different. No, sir. No, sir. A charge sheet without FSL report is no charge sheet. We have rightly or wrongly held so. We
No,
will
you see,
grant.
where is the scope? You see,
We will
what court
grant.
will not accept that. The moment charge sheet is filed, the court will consider it as a charge sheet. So
We
that
will grant.
FSL is the point of merit.
Issue. The petitioner says that he is in custody for 212 days. Stop. The charge sheet was filed, comma, although within the statutory period of 180 days, comma, but without the FSL report. Stop. Such a charge sheet is no charge sheet at all. Stop. He is entitled to statutory bail. Paragraph. Learned state advocate opposing the prayer for bail says that, what do you say? Nothing. Says that it is true that, candidly admits that FSL report is not available even as of today. Even as of today. Paragraph. Two division benches of this court have held that unless the FSL report accompanies the charge sheet in an NDPS case, comma, upon, the charge sheet is of no value. Stop. Paragraph. For the reason aforestated, comma, we are of the view that the petitioner is entitled to statutory bail. Stop. Accordingly, released.
For the petitioner, same thing is there. I have been custody for 266 days. Charge sheet filed without FSL.
Is the charge sheet available now? I'm sorry, the FSL report available now?
No, Your Lordship.
Same order.
Several intimation was done by the IO, but till date we have not received the.
Same order, it had
Same.
266 days. কোনটা?
যেটা কল হয়েছে সেটা
7 নম্বর তো? 7 নম্বর তো same order.
সেম অর্ডার।
ডিটেনশনটাকে
No, ওইটা 266 days.
Email.
ও শোনো, ফিমেল মানে ওইটা থাকবে না। জানো তো তুমি রিপোর্ট টু দি
Final presentation is in languishing in custody since 451 days.
Before he argues, my lord, 1 day accommodation, my lord, on behalf of state.
not today.
Item number 9.
My lord, I am for the petition. My lord, 9 and 10, my lord, arises out of same case. One single CDO.
Hello,
Yes.
petitioner is languishing behind bar for near about 11 months, my lord. The contraband the contraband recovered from this petitioner is, my lord, 287 grams of brown sugar, slightly above the commercial quantity, my lord. My lord, there is a gross violation of Rule 14 of the NDPS rules 2022, my lord. Because the FSL report came after a gap of near about 95 days from the date of sending of the samples to the FSL center.
Yes.
So in the
Was
rule,
the FSL report filed with the charge sheet
yes, my lord,
within
it has been-
180 days?
It has been filed, my lord, but the report came after 95 days, and there is no explanation for such delay because.
What is Rule 14? Where is Rule 14?
Yes, my lord.
আমাদের বই নেই হয়তো NDPS বার করে রাখবো।
NDPS টা একটা আছে এখানে?
Rule 14 states, my lord, expeditious test. Prescribed period is 15 days and grace period is another 15 days, my lord, totaling 1 month.
May I say, in dates, my lord, inventory was done on 8th of February 2023, 8th of February. And my lord, article sent by the IO to the CFSL, my lord, on 16/12/2023. My lord, that, my lord, no, 8th of December, inventory was made, and my lord, 16th of December, sent the CFSL, sent to the CFSL. And my lord, report collected by the IO, 18th of March 2020.
That is what he's saying, beyond 15 plus 15 days,
Yes,
but it
My lord, in this regard, my lord, I would like to place coordinate bench judgment.
Coordinate bench has said that for infraction of Rule 14,
Yes, my lord.
will entitle you to bail.
Yes, my lord.
Show us.
Yes, my lord. First paragraph, my lord.
Copy আছে? Copy. কত নম্বর? ও,
এখানে প্যারাগ্রাফ 3 তে একটু অন্য ভিউ নিয়ে একদম মানে কোয়ালিটিটা দেখেছি আর ওটা দেখেছি আর কি। Expedition. মানে এর মধ্যে সুবিধার মধ্যে কোনো irregularity বা কোনো expedition নেই। এটা কি যেটা দিয়েছে তার ঠিক হয়নি সেটা বলে হ্যাঁ distinguish করে রেগেট করে আসলে মাত্র distinguish করে ইন্ডিয়া প্রিন্টার ওটা ফ্যাক্ট distinguish করে দিচ্ছে ওটা। Is anything else apart from Rule 14?
Yes, my lord. The charge sheet was submitted on 13th of May 2024, my lord.
The earlier the case relied by you, in that case, charge sheet was not submitted.
Yes, my lord.
But in this case, the charge sheet is already submitted.
My lord, charge sheet was submitted on 13th of May 2024. With
Within
the
180 days?
Within 180 days, my lord. And with the CFSL report. But the report, the very mandate of that provision, Rule 14, states that maximum 1 month. It
So
cannot be beyond
that is not our interpretation, sir.
My lord, the coordinate bench has granted bail on that ground only.
Not fully on that, but there
Not
are other
fully,
grounds.
Correct.
My lord, paragraph.
We have read
3.
it, sir. We have read it.
Paragraph 3, my lord.
Issue.
My
Sorry.
lord, second thing, my lord, charge has not been framed yet, my lord.
Anyway, you come after some time if the trial does not proceed.
Yeah, we are giving you a choice. Either suffer a rejection or you can.
Not press. But then at this stage, I'm not pressing.
Not pressed.
But 10 also, 9 and 10.
Same.
Same, my lord. Same, my lord.
Same.
Not pressing. 11. 11, no, 21. Countless full.
11, my lord, one day accommodation, my lord, just now I received the case diary.
Well,
Item number 12.
Lordship, item number 12, kindly keep it on Wednesday. Gratefully.
Item number 13.
I'm for the petition. Lordship, I have suffered earlier rejections,
How many?
2. Now, after the charge sheet was submitted, the copies were supplied to me. After going through the copy, I have understood that has been a violation of section 52A, which is a mandatory provision. May I show it, Lordship? After
Please.
submission of the charge sheet, after getting the copies, Lordship, here is the order of the court for inventory. So kindly see this. In a nutshell, Lordship, here, second judge is copied to you. Second judge is copied. Lordship, kindly sees the last paragraph. Therefore, now the date, very important, Lordship. The samples were handed over to the investigating officer on this is the date. Now, Lordship, I have filed the examination report, FSL examination report, which is annexed with my petition. And this is the date, Lordship. Certified copies are there.
Page?
Lordship is certified copy.
Oh,
Forensic examination report. The samples were received by the Central Forensic Science Laboratory on 7/11/2023. 7 sample date of receipt is 7/11/2023. So the samples after inventory were handed over to the investigative officer after 7/11/2023. So the samples which were sent for by the investigating officer were not certified by the magistrate. Now, in this regard, Lordship, I place a judgment of 2024 of the Honorable Apex Court. What happens regarding? Kindly see paragraph 26. Similar circumstances. Lordship finds from the order, it was handed.
No, where is the relevant rules that say 52A?
52A.
Rule 52A.
52A. Lordship, the Lordship knows better than me, but for my satisfaction, the rule says the samples have to be placed before the magistrate. The inventory has to be prepared. It has to be certified by the magistrate.
is it the rule of section 52?
Section 52.
Section 52. Yeah.
And after that, after the certification and the samples have to be sent to the
Correct,
FSL report.
correct.
Now, Lordship finds from the order.
What I did not follow is these dates.
Lordship,
7/11.
Lordship, the order says the date was, therefore, may I read last para? I have prepared the certificate of correctness of inventory, photographs and samples of seized contraband in my office. The newly sealed label envelopes along with the certificate, the photographs and the DVT contain the digital images are hereby handed over to the IO of Naxalbari Police Station
On 16.
on 16/11/2023.
Correct.
Now, kindly see the Lordship, the forensic examination report which I have received. I have annexed, Lordship. Date of receipt is 7/11/2023. So prior to inventory,
1 second. Date of receipt is?
7/11/2023.
Yes.
So prior to inventory, the samples were sent for forensic.
Yes, yes.
Now, Lordship, kindly see is the judgment I have given, Lordship, para 26.
In that page, page 156, that was already handed over to your lordship. First paragraph.
Page 156.
No, your lordship. First paragraph, kindly see.
Certifying the corrected inventory. He certificate is dated 16/11.
One Xerox page was handed over by the.
It was supplied to us after
On
on 27.
Inventory done on 17th of October.
Okay, you see, certification was done at the later stage.
Yes.
Not only certification, Lordship,
Yes,
kindly
yes.
sees the paragraph, kindly. Lordship sees the paragraph which says, I have prepared the certificate of correction of inventory, photographs and samples of seized contraband articles. So samples were handed over to the IO on 16/11. So after the samples were handed over to the IO, the samples ought to have been sent to the forensic.
Yes.
So the samples which were sent to the forensic were not handed over to by the magistrate.
52A to A was not complied.
Not complied with. This is a mandatory
So
provision.
let us consider the judgment also. Where is
Judgment,
the
Lordship.
provision of the judgment?
Lordship,
The-
kindly see para
Fact of the
26. Admittedly, no, may I read it, Lordship? No proceeding under section 52A NDPS Act were taken by the investigating officer, P5, for preparing an inventory and obtaining samples in presence of judicial magistrate. Here also it was done on 1611.
Yes,
In view of the
Mr.
matter,
Ganguly, we are aware of this. The object is to ensure that the correct sample is
samples,
sampled.
Lordship.
Yes.
Otherwise, what is sent,
Yes.
God knows.
Oh, no, no. So
What
it
do
was
you
handed
say?
over on 1611,
Infraction of 52A has been held by the Supreme Court to be fatal.
Lordship.
Fairly submitted, Your Lordship, inventory done on 17th of October, and certification was, certificate was, and the sample was handed over to the IO on 16th of November. Prior to certification, he sent the sample.
Therefore, we have to
This
grant
is
it.
fact.
We have to grant it.
So that is the violation of the procedure.
Absolute violation. Yes, hello. Esho. The petitioner you're in custody for?
Lordship, 399 days.
The petitioner renews his prayer for bail, which was rejected twice earlier. Stop. He says that he is in custody for 399 days. Stop. After, he says that after he received the papers under section 207 CRPC, comma, he has detected that the investigating authority has not complied with the mandatory provisions of section 52 capital A of the NDPS Act, 1985. Stop. He says that without compliance of such provision, comma, the FSL report would be an useless piece of paper and cannot be admitted in evidence. Stop. He relies on a decision of the Honorable Supreme Court in the case of Eta the other way. Eta, such and such. Stop. He prays for bail on the aforesaid ground. Paragraph. Opposing the prayer for bail, comma, Learned State Counsel says that commercial quantity of contraband was recovered from this petitioner. Stop. Twice his prayer has been refused. Stop. Prayer for bail has been refused. Stop. However, comma, in his usual fairness, he says that the sample was sent to the FSL by the investigating officer even before the same was certified by the magistrate as required under section 52 capital A of the NDPS Act. Stop. Paragraph.
Certified, handed over to the IO. Certified on 17th of October, prior to sending the sample.
Where do you get that?
Well, this is the page.
Then what are you showing me?
I have the page.
Lordship,
But I have.
magistrate had this is the first
First
paragraph.
First paragraph. Kindly see the first paragraph.
I fixed 17/10/2023 for holding the processor certificate on inventory. The date was fixed on 17, but it was certified on 16/11/2023.
Certification done.
The date was fixed on 17.
Next. As per order number 1, dated 16/10/2023, IO presents. First paragraph. Inventory done on 17th of October.
Ultimately done. So anyway, certification was done on 16/11.
And sample was handed over on 16th.
To the IO
On 16th.
You will learn.
But on 7th already it was sent to investigator.
Okay, prior to that it was.
Prior to
sent-
that it was
Yes.
sent.
Even before the same certified by the magistrate as to it.
So it was certified
Certified.
when?
Certified on 17th.
16/11.
17th.
No, no.
First paragraph. madam.
No, last paragraph.
First paragraph.
Therefore, I have prepared this certificate of correctness, etc. in my office and hereby handed over to the police station on 16/11.
Certificate
The date was fixed on 17 October. That is the mistake he is making.
Please. But certificate was signed on 16/11/2023 and hand over to the IO and this with along with the samples.
Without signature,
Yes.
where is the certification? Of what value is a piece of paper? without his signature?
That's your lordship, but inventory was done on sale.
Whether that was a certificate or not.
Yes.
ঠিকই আছে।
It says that the sample was sent to the FSL by the investigating officer even before the same was certified by the magistrate as required under section 22 criteria of the.
Paragraph. We have seen the material in the case diary. Stop. It appears that the FSL received the samples on November 7, 2023. Stop. However, the concerned judicial magistrate signed the certificate on November 16, 2023, i.e. after the sample was sent to FSL. Paragraph. In view of breach of the mandatory provision of Section 52, capital A of the NDPS Act, and in view of the judgment of the Honorable Supreme Court in the case of such and such eta, comma, we are inclined to allow the petitioner's prayer.
Deeply obliged, lordship.
Accordingly, করে যেটা usual order করে দাও।
Deeply obliged.
Lordship, I'm praying for Wednesday. Kindly fix it on Wednesday, your lordship. Grateful.
Item number 15. For the petitioner, my lord. My lord, this is a renewal of prayer for bail. On earlier occasion, your lordship was also pleased to reject my application, but subject to correction, I am trying to invite your lordship's candidature about the page number 50 of my application. Particularly, my lord, paragraph number 3, 4, and 5, on the earlier rejection was there.
Page 50.
Page 50, my lord. Paragraph number 3, 4, and 5. Whereby earlier bail was rejected.
6th of March.
6th of March, my lord. It's a clear case of violation of 309 of the subsection 2 of CRPC. My lord, custody since 813 days. My lord, kindly see the last order.
No, 6/3/2024, your bail petition was last rejected.
Lastly rejected.
Okay, and you are in custody?
For 617 days.
617 days.
Which is to 1 year and
More than 2 years, man. Near about 2 years.
what is the stage? Oof. What is the stage?
Milord, on the
Copy has been
application, Milord, this honorable court has directed framing a schedule for evidences. Milord, that has been done, Milord. 7th of this month, Milord, has been 7th of this month is the date fixed for consideration of charge and thereafter prosecution evidence.
How many witnesses are named in the
20
charge?
witnesses on specific instruction. I am submitting, Milord. 6 months time, Milord, will complete the trial.
No, actually, you see, what was the last order? 6/3/2024. Yes,
That is the last rejection order, Milord.
yes, no progress.
But even in this application, Milord, there are several orders passed by the coordinate benches. No.
Page 5.
No.
Paragraph 5.
No.
My lord, may I take
Sir,
one interjection, my lord?
One thing, we cannot frame a time period for the trial court. The latest Supreme Court
Lordship.
rulings are to that effect.
Lordship,
We either grant or reject.
Lordship,
By the order by which his earlier prayer was rejected,
Lordship.
the coordinate bench granted him liberty to approach the court if the prosecution continues to fail in its duty and no progress in trial within 6 months from
Lordship.
today.
Lordship.
Now, what progress have you made from 6th of March?
Now, my lord, after the last rejection, my lord, there are several accused persons absconding. My lord, due to that, some delay occurred.
But after they have been apprehended, my lord, now the trial, my lord, the coordinate bench. My lord,
You see, he will not abscond. He is a government
no, my
servant.
lord, there is a difficulty, my lord, I'll
Yes.
tell your lordship. My lord, he is the employee of the Jalpaiguri,
Yes.
Jalpaiguri Jela
See, the
Police.
considering
And
the
my lord,
nature of offense,
difficulty is,
whether he will abscond or he has
My
no
lord,
scope to tamper with the witness.
yes, my lord, that is our apprehension because most of the witnesses, my lord, are the employees of the Jalpaiguri Jela Police.
Yes, yes.
And they are at high government, Jalpaiguri municipality.
Yes.
And there are high chances, my lord, that the prosecution witnesses may be tampered by him since, my lord, they used to work together.
We will keep him out of the
Yes,
territorial jurisdiction.
My lord, may kindly appreciate one thing, my lord, if I get 6 months time, my lord, I will do it.
But
My
you
lord,
see,
may not
he has
take-
already undergone custody for almost 2 years and see the nature of offense.
My lord, 83
If-
lakhs
if-
public money, my lord.
Very well.
Lordship.
If the trial will not be vitiated, definitely that should be considered. You see, there is no scope for the trial to be vitiated. Is it so easy that he will tamper so many witnesses?
My lord, because the prosecution witnesses, my lord, they used to work with him, my lord.
No.
So we have,
The de facto complaint is the chairperson.
Sir,
He-
you don't understand the court's mind?
My lord.
Then why are you speaking?
My lord.
Sir, we are minded to grant him bail. You just tell us you want him to be outside with jurisdiction.
Darjeeling jurisdiction.
my lord, outside the jurisdiction of Jalpaiguri.
Jalpaiguri district.
My lord.
Issue. The petitioner renews his prayer for bail, which was rejected earlier on March 6, 2024 in CRM DB 331 of 2024. Stop. By the said order, the petitioner was granted liberty to approach the court for appropriate orders if the prosecution continues to fail in its duty and no progress in the trial within 6 months from today. Stop. Unquote. Paragraph. The petitioner says that charge is yet to be framed. Stop. 20 witnesses have been named in the charge sheet. Stop. Trial has not even begun. Stop. It is anybody's guess when the trial will conclude. Stop. Paragraph opposing the prayer for bail, learned state advocate says that certain co-accused persons were absconding. Stop. It took some time to apprehend them. Stop. They have now been arrested. Stop. November 7, 2024, has been fixed as the date for consideration of charges. Stop. The trial may be concluded within 6 months. Stop. Not all prosecution witnesses named in the charge sheet may be examined. Stop. The accused persons are involved in defalcating public money to the tune of rupees 83 lakh. Stop. It is if the petitioner is granted bail, it is very likely that he will tamper with evidence and intimidate prosecution witnesses. Paragraph. We have considered the rival contentions of the parties. Stop. The petitioner is in custody for
813 days.
Once you say 600, once you say
613 days.
613
6-1.
for 613 days. Stop. That is a long period of time. Stop. Trial has not even begun. Stop. We do not see any possibility of an early conclusion of the trial. Stop. Paragraph. However grave the allegations against an accused person B, the person cannot be kept in incarceration for an indefinite period of time without carrying the trial to its logical conclusion. Stop. Article 21 of the Constitution of India contemplates that every under trial has a fundamental right to personal liberty and speedy trial. Stop. If the state or the concerned court does not have the wherewithal to bring the trial to an early conclusion, comma, then the state ought not to oppose an under trial person's prayer for bail. Paragraph. On the touchstone of Article 21 of the Constitution of India, and seeing that there is no possibility of an early conclusion of the trial, comma, we allow the petitioner's prayer for bail. Accordingly, করে একটা থাকবে তোমার, will stay out of the district of Jalpaiguri, excepting for attending court proceeding, and we to report to the as a furnished address where he will be staying, to the local police station, and report to the OC once every week of that police station. Our usual zero থাকে, not temporary.
Grateful. I'm grateful.
Item number 16.
Lordship, I beg to appear for the petitioner in item number 16, Lordship. Am I audible, Lordship?
My lord, as because the depositions are required as per the last order.
Yes, tell us. You
Lordship,
want, not today, when do you want it?
My lord, on Friday, my lord.
Lordship, I am in custody for 1,915 days, Lordship.
Oh, 4 days may not make so much difference. Friday, come back on Friday.
16, man.
Friday. Friday.
Friday.
What is the stage?
My lord, all the witnesses are being examined. Only one IO was left as per.
Come back with instructions.
Well,
Almost 3 years in
Lordship,
custody.
for 5 years, Lordship.
All other
For 5 years,
witnesses
not
are
3 years,
already been
Lordship.
examined, my lord.
Anyway.
That's why they were to consider the
Yes, which
witnesses
section?
deposition.
4 and 6 of POXO Act, Lordship.
No. Hey, Shuno, Pritam.
Kindly fix it on tomorrow, Lordship.
Come back on Friday.
Well,
Obliged.
Item number 17.
my lord, one day accommodation.
Not today.
17. And my lord, in 17, my lord, there is some difficulty with respect to service. So, my lord, let the police, my lord,
Boxo?
intimate. Yes, let the police
Dekho.
intimate.
Friday.
How
Then
soon can you
Friday,
sell? Friday. Lekho, learned advocate for the petitioner says that service could not be effected on the de facto complainant oblique victim girl. Stop.
Victim girl is no more.
Oh, no more. Oh, on the de facto complainant. Stop. Paragraph let the state effect service on the de facto complainant and file a service report on the next date. Paragraph list the matter once again on Friday date the other.
I'm great.
Item number 18.
Hey. Service of this bail petition. Service of this bail petition.
Yes, my lord. I'm for the petitioner on
Yes.
item number 18.
Boxo naki?
No, my lord.
302, my lord.
302. My lord, present petitioner is languishing in custody since 142 days, as well as he surrendered before the learned trial court below on 15th of June 2024 after his prayer for pre-arrest bail was turned down by this court.
You are what, husband of the victim?
No, my lord. I am the brother of the husband. I am brother of the prime accused, and only because I booked in this case that I am the resident of the same house. And the father of the prime accused already enlarged on bail on 25th of September 2024 in connection with CRM.
Charge sheet has been issued under 302.
No, my lord.
498, 340.
হ্যাঁ তাই তো দেখছি
Person from the,
302 বলছি যে।
302 is added?
No, my lord.
kindly see, as because I obtained from the
304.
Charge is framed.
304 and 2, 302.
No, charge is framed under
Which
section? 302, your lordship, may I?
Charge has been framed.
Framed, your
Charge
lordship.
has been
Charge-
framed.
Even evidence is going on and schedule has been fixed, your lordships.
Till now,
Husband is in custody.
Yes,
husband is in custody, mother-in-law is in
father-
custody,
all are involved, your lordships.
father-in-law
Earlier,
enlarged on bail.
because they are the brother-in-law, but that earlier occasion, your predecessor already considered and rejected.
That was, my lord, a pre-arrest bail application.
May I?
There is no
Where is the
direct.
CD?
There is a sufficient material.
No,
against the brother-in-law.
allegations against
Yes, sir.
No, no.
Lordships, 164 statement is there.
How many witnesses are there?
Lordships, charge sheet.
There are 14 witnesses.
1-4.
One.
How many have been examined?
No, till today, not a single witness has been examined.
You said,
Lordships, schedule has been framed.
Page 25 is the general allegation.
No, my lord.
No,
there
where is the specific allegation against this
120,
person?
164.
Yes, which page?
164 page is 28 and 29. And apart from that, your lordships, postmortem report, there is only others injuries also.
Yes,
So-
so 302 is added anyway. Let us see page 28.
Lordship 28 and 29. They are demanding money, and when the poor father could not fulfill their illegal demand.
Sudeep Kuri.
Sudeep Kuri is the brother-in-law who is.
Lordship, earlier occasion, they have taken the plea that he not used to reside in the
Yes,
same
yes,
house.
yes.
Yes, where is the page 28 and another?
28 and 29.
My lord, there.
Lordship, another 161, page 25, your lordships.
Page
25.
25, yes, we have gone through that. Page
Rinku
25.
Das, video call
Yes.
showing that neck injury.
Maybe, my lord, but
Maybe.
but
one of
this
the guy-
present petitioner is
So,
not directly involved.
PM report?
PM report lordships. Postmortem. See, I have already flapped it, lordships. Last page, your lordships.
PM report.
So it is clear case of maybe 302. Chart already framed. Evidence is going on, lordships. And charge frame 22 August 24 and evidence started 8 October to 16/11/24.
Till today, not a single witness has been examined. 18th, on 18th of October, there was no witnesses available in the Lane trial court below. Because I am the advocate of
Yes,
record.
father-in-law is on bail.
Yes,
Lordship,
Yes,
I
my
don't
lord.
know. as
Yes, my
because
lord.
My CD there.
my lord, I supplied the order sheets, but there was some mistake from my side.
I don't.
that
found
actually,
any bail
uh,
order.
The bail order was passed on 25th of September,
Yes.
but this is the correction copy of the same order.
Where is the main order?
Main order, my lord, give me some 10 minutes password. I will show that.
Or shall we make it not today?
Not really.
My lord, 10-minute password.
Yes, take instruction. Come.
No, my lord, I have the copy. Just I have to print
But-
the same. Just I have to
My
print.
submission is, I'm not asking about the father-in-law.
Sir.
Brother-in-law is involved, your lordship.
Sir, if the allegations are general, specifically only against the husband. That he used to return home at night in a drunken state, used to beat up. Otherwise, the allegations are general against all family members. In that background, if the father-in-law has been granted bail, we want to see, then why should not, because there's no specific mention of Shudip Kuri. Neither in 161 nor in 164.
My lord, I need only 10 minutes, my lord.
Bring that.
Only 10 minutes. Gratefully.
Pass over for it now. It's going to get that. Which one? Which one? Yes, you want accommodation? Come back tomorrow. Leave করে দাও একটা leave is granted to learned advocate for the petitioner to correct the cause title of the bail petition. Paragraph on the request of learned state advocate, comma, let this matter stand adjourned for the day.
I am for the petitioner.
State, 20 state. Yes. Yes.
I served
326, 307, 120B, 109 and 34 of IPC, my lord. Apart from this petitioner, my lord, other 6 persons are already enlarged on bail, my lord, including the principal accused, my lord. His language.
In the 164 statement, victim names all the persons except this person, but the rest persons are
On bail.
clearly submitted to the lordship. Charge sheet submitted, charge not framed.
When was the charge sheet submitted? You are in the jail for how many days?
8.
Issue. Yeah, of course. Not only objection, vehement objection. You are in custody for?
My lord, more than 6 months.
The petitioner says that he is in custody for more than 6 months. Stop. He says that he has been falsely implicated. Stop. 6 other accused persons, 5 other accused persons, including the prime accused, have been enlarged on bail by
The court below.
the learned trial court.
And 1 person has been granted anticipatory bail.
Stop. Another accused person has been granted anticipatory bail by this court. Stop. He says that he stands on a better footing than all the other accused persons. Stop. He prays for bail. Paragraph. Opposing the prayer for bail, comma, learned State Council apprises us that tells us that tells us that the victim has suffered grievous injury, as would appear from the medical report. Stop. Paragraph. We have seen the material in the case diary. Stop. You said that 5 were named where? In the
164 statement of the victim.
we find from the statement of the victim recorded under section 164 CRPC that 5 accused persons who have 6 accused persons are named by the victim as the assailants. Stop. All those persons are 5 of those persons are on regular bail and 1 person has been granted anticipatory bail. The petitioner was, however, not named by the victim in the petitioner was named. Oh, stop. We therefore see that the petitioner is similarly circumstanced as the other accused persons. Stop. Hence we are inclined to allow the petitioner's prayer for bail.
Satisfaction to CGM Jalpaiguri. CGM Jalpaiguri. Deeply obliged.
We will come back in 5 minutes. This is what we do in Calcutta also. It's medical advice to rise for 5 minutes. Bolo.
There is the copy of the bail order and correction order. Both are annexed.
Postmortem report suggests victim committed suicide.
Suicide.
Yes. The petitioner is the brother-in-law, bracket lekho, husband's brother of the victim lady. Stop. He says that he is in custody for
142 days.
142 days. Stop. The father-in-law of the victim lady, namely Dulal
Dulal Kuri.
Kuri, Kuri, was granted bail by a coordinate bench by an order dated September 25, 2024, passed in CRM. Anticipatory bail.
No, my lord, there is a typographical mistake. So
Oh,
there is a correction order.
Right. CRM bracket DB 486 of 2024. Stop. The petitioner says that there is no specific allegation against him in the statements of witnesses recorded under sections 161/164 CRPC. Stop. He stands exactly on the same footing as Dulal Kuri. Stop. A paragraph opposing the prayer for bail, learned state advocate says that all the family members are involved in the alleged crime. Stop. They used to torture the victim lady, which drove her to commit suicide by hanging. Stop. Paragraph. We have seen the material in the case diary. Stop. The statements of the witnesses are all general in nature, excepting that the husband of the victim lady has been specifically implicated by both the victim's sister and father. Stop. Paragraph. In view of the fact that the petitioner appears to be similarly circumstanced as the father-in-law of the victim, who has been granted bail by this court, and there being no specific allegation against the petitioner, and also keeping in view the period of detention of the petitioner, we are inclined to allow the petitioner's prayer for bail. Accordingly, করে দিও. Yes. Not to.
Assumption that is maybe 300.
Disposed of করে দিয়ে করো, needless to say, the observations made in this order are only for the purpose of disposing of this bail petition and will have no effect on the trial.
Grateful, your lordship. Deeply obliged.
Your lordship, I'm for the petitioner. Your lordship, I'm for the petitioner. Kindly keeps the matter on Friday, your lordship.
Very well, Friday.
Grateful, your lordship.
I'm for the petitioner and I'm praying for please kindly fix this matter day after tomorrow because affidavit of service is still pending.
I'm for the petitioner, my lord. My lord, this is the affidavit of service which clearly shows the intimation served upon the victim. I have downloaded that on 3rd November. Not 376, my lord. My lord, may I?
Hey, live streaming টা pause করো.
My lord, may I?
Live stream বন্ধ করো.
Now, my lord, I am in custody
24 টা তো 376
376. I am in custody is 5 years and 8 months and 4 days.
Lord, burn injury was there, Lord, the victim succumbed to death.
Why this delay? File a report. Let the state file a report.
Lord, 16 witnesses have been examined.
Doesn't matter, over 5 years, 8 months.
So he's the husband.
Yes.
Your first time prayer or renewal?
Renewal, Lordship.
When was it last rejected?
Lordship, last on
Sir, you should do your homework and come
29th January, Lordship.
this year.
Yes, Lordship.
Where is that order? Yes.
Lordship, page number 9, Lordship. Annexure P1.
Lord, I can find from my memo of evidence that 14th of November is fixed for examination of the autopsy surgeon. And my lord, and warrant of arrest has been issued by the trial court, my lord, to secure his presence. So, my lord, these are the difficulties, my lord, the trial court has faced, my lord, while proceeding with the case.
We understand everything, sir. You may have an excellent case on merits to secure his conviction. Do it.
Lord,
Punish him. But 5 years, 8 months, you cannot. You are aware of the recent order judgments of the Supreme Court. You file a report. Keep it on.
As well as your CD also.
the CD I have today.
Okay. So bring it tomorrow.
Report. কালকে পারবে না
Oh,
report.
day after tomorrow.
When report will file Friday?
Thursday.
Thursday. The petitioner says that he is in custody for 5 years, 8 months, approximately করে দেবে 5 years, 8 months, stop. Only 17 out of 28
Yes, Lordship.
charge sheet named witnesses have been examined, stop, on the ground
16
of
out of 27.
16 out of 27.
I think it said 16 out of 27.
16 out of,
27.
Lastly, also one additional witness is
so 17 or 16, how many examined?
17.
17 out of 20, ঠিক আছে, থাক নাকি?
আরো 10টা বাকি আছে।
Stop. He prays for bail. He renews his prayer for bail, which was rejected earlier on January 29, 2024, on the ground of delay. Paragraph, let the state file a report explaining, if it can, the delay in progress of the trial. Stop. The report the report shall also indicate how many more witnesses the state prosecution intends to examine. Stop. List the matter once again on Friday date when the case diary will also be produced.
I'm grateful.
Good.
27, and for the state. In this case, an unfortunate incident took place, because I'm very fairly submitting. On earlier occasion, the petitioners got the privilege of bail. Subsequently, they have not been informed. They again approached before us, and without verifying the same, we have filed the same. And on last occasion, his lordship was pleased to issue a rule to show cause as to why their earlier bail application will not be cancelled. That is the actual fact, my lord. Now, my lord, I have instructed my client to file a show cause by supported by an affidavit. If matter may be fixed on that Friday, I will file the.
If you also kindly see the orders.
I have
Order
already.
dated.
Order dated,
5th October.
yes.
I
Yes,
have already said the entire
They
fact. to your
obtained
lord.
bail on the
I've already said.
11th September. Again, they
Yes.
filed on 30th.
Sir,
No, 11th September, they obtained anticipatory bail.
Anticipatory bail.
And was there any condition in that anticipatory
No,
bail
no, my lord.
to surrender or whatever
No,
it is?
no. Actually, due to mistaken of.
No, who was the deponent in those two applications? Was the same person or different person?
No, another person. Lawyer
No.
is same. I'm very fairly submitting. I am the lawyer, but that is my fault. That is my fault.
Deponent is different.
Different is different. I'm very fairly submitting. In both the cases, I am the lawyer. But
Yeah, all of petitioner number one.
I never
That is a
hit
question.
my fault.
Whether there was any suppression.
No. I am very. There is a
Oh, that earlier bail.
Yes, they got a bail.
sir, let them answer the rule. Rule has been issued. Rule has been served.
No,
Let them-
not been served. It has not been served. I instructed my client to appear before your lordship. It is an unintentional mistake from our end. It is not a case that the earlier was rejected, we have filed subsequently, otherwise allowed. It is our fault, my clerk's fault, that without verifying the same, he has filed again, and that was.
Can you ascertain who are the deponents in those two cases?
My lord, fixed on Friday, my lord, I will.
Those petitions from those two petitions.
My lord, I will apprise your lordship properly. Make it from Friday.
Read order dated. October 5, 2024. Stop. By that order, a coordinate bench issued a rule, capital R, against the petitioners, calling upon to show cause as to why the anticipatory bail granted to them on September 11, 2024 in CRM bracket A 648 of 2024 should not be cancelled. Paragraph, learned advocate for the petitioners seeks a little time. Stop. As requested, let this matter be listed again on Friday.
Grateful.
I'm grateful. Item number 28.
In item number 28, 29, I prefer not today.
Not today.
For the state.
Hmm.
Okay. Item number 30.
I am for the petition.
State.
My lord, this is a case of previously 498A only. I am the unfortunate.
The de facto was to be called, and I think lordship de facto is present, and lordship, what I see from the other records, lordship, after this case, consecutive lordship FIRs have been lodged against this petitioner, lordship, alleging that this person has been threatening the victim, as well as lordship, he has taken some photos, lordship, he
35 out of the state final.
So item 35, kindly fix this matter on next.
Next
week,
circuit.
Next week, next.
Not this week.
Much.
36.
That bring or not today.
Not today.
37.
27 lots, I am for the petitioner. The allegation is.
State. Not today. Not today. No. You are there?
Mr. Laxam will appear, Lordship. Please come.
Yes.
The allegation is under section 69 of the BNS, promise of marriage and physical relation. The allegation is completely false. Lordship.
As well.
Wednesday.
As well.
39.
Chalo.
39 ke only state.
You're in 39.
Yes, I'm for the petitioner, madam.
State.
39.
Not today.
40. I'm for the petitioner, madam.
40 you are appearing.
I'm not today.
Not today.
41. And I'm for the. 41.
41 I am for the state.
Yes.
44.
But I am appealing for the petitioner, Lordship. But this is a matter, my lord, relating to the dispute.
My lord, in
My lord.
accommodation, my lord, I'm not holding the same.
Not today.
Wait, Lord.
Yes, my lord, answer the petition.
Not today.
Not to the state. He asking
46.
I have 50. 50 not. 51. 51.
Lordship, kindly fix the matter on 13th November.
13th November.
last day.
Oh, really?
14th was the last working day.
14, that's good.
Working day.
I have 52.
Correct. 13 says. And keep it that.
Okay, 13th.
13th, yeah. Next. नहीं, not today, sir. Not today.
Item number 53.
Chalo, chalo.
One pass over. Pass over.
Item, yes.
Item number 42. Just wait.
Item number 54.
54 today is the pre-constitutive day after tomorrow.
Day after tomorrow, এবারে pass over টা ডেকে দাও.
Pass over item. Item number 42.
198, 304B, my lord, allegation, all are in-laws member, my lord. Good, your lordship, my lord. Husband arrested and granted bail by the honorable. All are in-laws. And nature of allegations, and omnibus charge sheets copied.
164 of the mother and there is 164 of the accused. And the others are hearsay. 164 of the mother, which is more widely further. Naming all the accused and the husband has been arrested.
Husband has been arrested,
Arrested also went down.
Granted bail.
granted bail also.
Although that is any rights.
This is 164 of the mother of the victim. And another?
Another is 161 of the accused and others are hearsay.
161 of?
161 of the accused who has been arrested. Lordship, he has given the lordship what he has done during the alleged time. Lordship, and others are lordship called neighbors, relative. 161 of page number 1617. Hearsay. Each one,
Issue. The petitioners pray for pre-arrest bail. Stop. They say that they have no role to play in the alleged offense. Stop. The victim lady committed suicide by hanging. Stop. They are the members of the family of the victim lady's husband. Stop. The husband of the victim lady was arrested and was thereafter enlarged on bail by this court. By this court. Stop. Charge sheet has already been filed. Stop. Paragraph. Opposing the prayer for anticipatory bail, comma, learned advocate for the state draws our attention to the material in the case diary, including the post-mortem report and the statements of witnesses recorded under section 164, sections 164 oblique 161 oblique 164 CRPC. Stop. We have also seen the statement of the victim girl's mother recorded under section 164 CRPC. Stop. Paragraph. On an overall assessment of the facts and circumstances of the case and the possible extent of complicity of the petitioners in the alleged offense, comma, we are of the view that immediate custodial detention of the petitioners may not be necessary so long as they cooperate with the with further investigation, comma, if any. Stop. Accordingly, একটা anticipatory bail order দেখে নিও। হ্যাঁ হ্যাঁ ঠিক আছে। এটা কত নম্বর?
Item number 55. 55.
Cancellation of bail.
Your Lordship, I'm appearing on behalf of the petitioner, Your Lordship, in this matter. Your Lordship, on the last occasion, there's a direction that the court below would consider, that is fixed on 21st of November, Your Lordship, that the petitioner preferred an application before the court below for considering section 302 in this matter, Your Lordship, and that was not decided. So the next date is fixed on 21st of November in the court below, Your Lordship. That would be reflected in the last order sheet itself, Your Lordship.
Who is for the accused? You are for the de facto. Who is for the accused?
We have served on several occasions, Your Lordship.
Lordship, he was present, right?
Last occasion.
Mr. A. Sharkar,
Yes, Your Lordship.
Mr. Shuprutim Nag.
Lordship.
So what happened in this case? Charge sheet was submitted.
Bail was granted by the trial court.
Under 304B, as because death occurred within 7 years of marriage. Now their prayer was, why 302 was not there? Our submission is that at the time of framing of charge, the trial court has ample power to alter the sections as per the case diary. So they had preferred one application before the trial court for adding section 302.
We'll urgent it be after 21st
Not
November.
That is the thing. Because if it is
It will take some time.
Hey, Ishu. This is an application for cancellation of bail. Stop. Today, comma, nobody appears for the accused persons. Stop. Paragraph, we find from the orders on record that the de facto complainant has made an application before the learned trial court for including a charge under section 302 IPC. Stop. That issue is pending consideration before the learned trial court. Stop. We are told that the next date fixed is November 21,
Lordship.
2024. Stop. Paragraph, let this matter be listed before the next circuit bench.
grateful. Next one also same.
Next one also same.
Two accused person.
Two accused person, same FIR.
Same.
Each. You put the eta hai. Grateful.
This one, my lord, I'm praying for day after tomorrow, my lord.
Day after tomorrow, Wednesday.
Not listed, but we are paying for next subject.
You are for the applicant.
Yes.
De facto.
Yes.
On the prayer made on behalf of the applicant in this application for cancellation of bail, comma, let this matter stand adjourned and be listed before the next available circuit bench.
State is represented.
Your appearance will be there. Give your name.
I'm grateful.
What I'm praying for not today.
Not today.
I'm applying for the petitioner. The application for relaxation of condition of bail. The petitioner was enlarged on bail on 13th of May 2024. Where the two conditions were there, not to enter into the jurisdiction of Mathabanga PS and to appear before the investigating officer of the Mathabanga PS once in a week. The petitioner.
There's 376.
Not 500. That should be continued. Charge sheet has already.
No, have you served this application on the victim? Serve and come back. The 376 is there. Serve and come back. Let Monday. Let copy of this application for relaxation of conditions of bail be served on the victim lady and affidavit of service be filed in court on the next day. Paragraph as suggested by learned advocate for the petitioner, comma, let this matter be listed again on Monday.
State is present, your lordship.
State, give your appearance.
61.
And for the petition, state has been served, but the victim, the mother of the victim has, delivery has not been completed.
When do you want it?
Monday, my lord.
Monday. Service is not complete. Stop on the request of learned advocate for the petitioner. Let this matter be listed once again on Monday date.
The state has been served.
State is appearing. State appearance to now.
After the state, my lord.
Petitioner not there.
Yes, Lordship, I am aware of the petitioner.
What is this restoration?
Yes, Lordship. When the matter was called on, Lordship, I have engaged in the court number 2, Lordship, that's why.
Yes, restoration.
Yes, lordship.
It was dismissed for default when?
Lordship, 24th September of 2024, Lordship. And I filed the application 4th of October, Lordship.
Esho. This is an
Objection. Lots otherwise, earlier bench we have lots of problem facing.
This is an application for restoration of CRM bracket A 558 of 2024, which was dismissed for default.
No, Lordship. Lordship, my Lordship. Bail was granted to me, Lordship. Thereafter, I filed a relaxation application, Lordship. That relaxation application was dismissed for default, Lordship.
Oh, CRAN 1.
Yes, Lordship. The dismissed for default application, Lordship, CRAN 2, Lordship. And relaxation, CRAN 1, Lordship.
So CRAN 1 was dismissed.
Yes, Lordship.
This is CRAN 2, what we are hearing
Yes,
now.
Lordship.
Kidana, Kidala. Of CRAN 1 of 2024, filed in connection with CRM bracket A 558 of 2024, comma, which was dismissed for default on September 2024, on September 24, comma, 2024 by a coordinate bench. Stop. CRAN 1 of 2024 was an application for relaxation of conditions of bail. Stop. Paragraph, we have heard learned counsel for the parties. Stop. Learned state advocate opposes the prayer for restoration and says that sufficient ground has not been made out for restoration. Paragraph, we are, however, of the view that learned advocate for the petitioner has sufficiently explained his absence on the day when the matter was dismissed for default. Paragraph, accordingly, the order dated September 24, 2024, is recalled. Stop. CRAN 1 of 2024 is restored to its original file and number. Paragraph, list CRAN 1 of 2024 on day after tomorrow.
Lordship.
Tarikh ta diya tha.
Grateful, Lordship.
CRAN 2 ta disposed of.
Lord, I am for the applicant. Lord, similar to the last matter, my lord, I was engaged in another court, my lord. I could not appear when the matter was called and it was dismissed for default.
Application for relaxation of bail?
No, application for bail.
For bail was
Yes,
dismissed. Issue 63. Anticipatory bail.
Anticipatory.
This is an application for restoration of CRM bracket A 610 of 2024, which was dismissed for default by a coordinate bench on September 11, 2024. State is there. Paragraph, we have heard learned counsel for the parties. Stop. The state opposes the prayer. Shall we? No. For the parties. Stop. Paragraph, we are satisfied with the explanation furnished by learned advocate by the petitioner for absence of his learned advocate on the day the matter was dismissed for default. Paragraph, the order dated such and such is recalled. Stop. CRM A 610 of 2024 is restored to its original file and number. Stop, let the said application for anticipatory bail be listed
Thursday, man.
on Thursday date the other. CRAN 1 disposed of.
Grateful.
Number 64. 55.
65, my lord, I am for the appellant, my lord. The state is the appellant here. My lord, challenging the order of acquittal passed by the learned sessions court, my lord. On the last occasion, my lord, the respondents appeared before this honorable court and prayed for filing their opposition to my condonation of delay application.
You are the state.
I am for, yes, I am for the state.
Respondents are not present
But they
today.
are not present today, my lord, but the earlier order will show, my lord, that they have been granted liberty to file opposition.
Yes, that time period has expired.
Yes.
How much time was allowed?
Maybe 4 weeks, my lord.
Actually, no, okay. Yeah. Yes, yes, long time. Serve another notice and come back. What else can we, even after a second notice, if they don't come, we will condone the delay. Sir, who appeared?
But Ms. Rima Sarkar and Mr. Pratap Khati.
You can serve on them
My lord.
also. Huh?
I'll do that.
নাকি party কে বলবে? নাকি sir, advocate দের বলবে? Appear করছে যখন। By an order dated September 24, 2024, a coordinate bench had permitted the respondents in this proposed appeal to file affidavit in opposition to the application for condonation of delay. Stop. Paragraph. Today, nobody appears for the respondents. Stop. We are of the view that one more opportunity should be granted to them. Stop. Paragraph. Let notice be served on learned advocates representing the respondents, intimating that this matter will be taken up again on Thursday date the other. Comma, when this matter will be listed again.
I'm grateful.
Six. 66, my lord, I beg to appear for the appellant, my lord, to the second appeal. My lord, I'll.
Why is it listed under the heading for dismissal?
Lord, I am not.
So why it is defective?
It's
Defective.
defective, my lord, I'll cure the, inspect the record, cure the defects immediately. My lord, takes it up for admission any day next week, subject to your lordship's convenience.
Very well. List on the request made by learned advocate for the appellant. Let this matter be listed again on Monday, next Monday, the other. So in the meantime, the defect in the appeal, as noted by the stamp reporter, be cured.
Grateful.
7. 68.
68 of the defective.
In this matter.
You will 68.
Yes, lordship, yesterday appeal.
Well, they have challenged the order of this single bench where there was direction to release the gratuity amount and they leave encashment.
No, 68 is restoration.
Lordship, registration already done, lordship.
Oh,
Application
earlier
to be
of a
disposed
lordship.
of. There was direction to prepare paperwork, Mara. But in the meantime, they have disbursed the payment, Mara.
Already
Then
remains.
Whether they
what
want to
remains
proceed
of the
with
appeal?
Yes.
Nothing?
Nothing, lordship.
Sure. learned advocate for the respondent, one respondent, one.
Yes.
Respondent oblique writ petitioner says that the order of the learned single judge which is sought to be assailed in this appeal, comma, has been complied with by the appellant, appellants. Stop. The gratuity amount that was due to the writ petitioner has been disbursed. Stop. Paragraph. Learned advocate for the appellants agrees with the submission made. না না আমি শুরু করেছিলাম কিভাবে? হ্যাঁ, ঠিক আছে। Learned advocate for the appellants agrees with the aforesaid submission. Paragraph. Since the order under challenge has been complied with by the appellants, comma, nothing remains in this appeal. Stop. The appeal stands disposed of. Mat number to mention review. Appeal being mat.
Grateful.
Dispose of করে দিলেন।
It's, my lord, and for the appellants, my lord, the appeal was dismissed for default, my lord, when the matter was called on, my lord, he could not appear. So, my lord.
Have you served?
My lord, the state.
Restoration?
Party here.
Huh?
State is a party here, my lord, state has, yes, my lord, yes, come.
This is a restoration application.
Yes, my lord.
No objection if the restoration application is allowed.
Very good. Can we record that?
Record well, then there's not a delay also, no 1 week delay. The registration filed after 1 week.
1 week delay.
No, not delay, filed after.
So within time.
Within the limitation period.
Can 3. This is an application for restoration of SAT 2 of 2023 and Can 2 of 2024, comma, which were dismissed for default by a coordinate bench on September 4, comma, 2024. Stop. Paragraph. We have heard learned counsel for the parties. Stop. The restoration application has been filed within time. Paragraph. We are satisfied with the explanation furnished by the appellants for absence of their learned advocate on the day the matter was dismissed for default. Paragraph. Accordingly, comma, the order dated September 4, comma, 2024 is recalled. Stop. SAT 2 of 2023 and Can 2 of 2024 are restored to their original files and numbers. Paragraph. Can 3 of 2024 is disposed of. Paragraph. Let the appeal and the connected application be listed on Monday date.
Yes, great.
এবার 70 হবে। আচ্ছা, দেখো দেখি।
Number 70.
There are 3 applications. We'll take them at 2 p.m.
There is a restoration application.
Achha, which one? Can
2.
Is there a delay?
Yes, there is a delay.
Huh? Let us come back. দুটোর সময়। এই কোন ঘড়িটা ঠিক? ওটা ছয় একটা বুঝি, একটা 13 পিক করো ওটা। দাও স্টেট তো ছিল আগে what is this restoration with prayer for condonation of delay
application
which is the delay condonation
Can be, restorations can be.
can 2 and what is can 1
Can is the petition of the petitioner.
oh and what is can 4
Can stay.
right so we are now concerned with can 1 can 3 এই কোথায় তো দুটো ক্যান না এটা তো অ্যাফিডেভিট অফ সার্ভিস ক্যান 2 দিচ্ছ কেন এই তো অ্যাফিডেভিট অফ সার্ভিস Esho, who was appearing for the state? Affidavit of service filed in court today be kept with the records. Stop. In spite of service, nobody appears for the respondents. এটা তুমি can 3 বলছি, হ্যাঁ? The can 3. So this is an application for condonation of delay of 3 days in filing an application for restoration of MAT 79 of 2023, which was dismissed for default, along with CAN 1 of 2023 on August 20, 2024. You are for the state?
No, Lordship, I'm for the private respondent. Lordship.
তাহলে ওটা বলো না তাহলে nobody appears for the state খালি করে দাও state respondents August 20, 2024. Stop. Causes shown being sufficient, the delay is condoned. Can 3 is allowed, huh? Disposed of. Yeah. Next now can 2. This is an application for restoration of MAT 79 of 2023, which was dismissed for default, along with CAN 1 of 2023 on August 20, 2024. Stop. Paragraph, we have heard, learned counsel for the appearing parties. You're appearing in this matter? Oh. Appearing parties, stop. We are satisfied with the explanation furnished by the appellant for absence of his learned advocate on the day the appeal was dismissed for default. Paragraph accordingly, the order dated August 20, 2024, is recalled. Stop. MAT 79 of 2023 and CAN 1 of 2023 are restored to their original files and numbers. CAN 2 disposed of. Paragraph lists the appeal and the connected application on.
Finally, direct the appellant to memo appeal, they did not give. Careful. Please.
Doesn't you are for all the respondents?
Respondent number 1, but we have not received any copy from their end.
Affidavit of service? Other respondents have not been served. But then serve, you have to serve at least. Yes.
Lordship, my client has not been. I have no opportunity to inform my client. He is out of his residence. He will come after few days.
Sir, this is a restoration application.
Definitely, we have something to say. On the last circuit, on all days, the matter was called for.
Anyway, you see, restoration application, things are matters on record, okay?
Yes.
So you can make your submissions, you just take a copy.
Give him, serve him. let service be effected on, the learned advocate for the petitioner says that the respondent numbers 5 and 6 have been served. Stop. Let service be effected on learned advocate for the respondent numbers 1. Only, you are only for 1.
Also state.
He is for 1 only. Then all the other respondents you'll have to serve. How can you serve by? What about 2, 3, 4?
The 1, 2, 3 are all the status one. 3, 4 is the regular authority. I am again.
1 is Ishita Das.
Yes.
He is appearing. He would love. On the other respondents, on the other respondents. Stop. List this matter once again. Porshudin day after tomorrow. Next.
Item number 72. Item number 72.
Lordship, this is a restoration application on 4th of September, when the matter had been called before the Honorable Division Bench. I was engaged on in
Have you
another.
served, madam?
Yes, yes.
Where's the
yes,
affidavit
Lordship.
of service? A copy.
Yes, respondent has entered appearance in this matter.
No, no, no. Your Lordship.
Respondent has not yet appeared.
No.
Oh, not yet appeared.
Party ki direct.
Why only 1 copy, madam? This is the division bench.
I will give your Lordship tomorrow.
File a copy in course of the day. Kesho.
Okay, your Lordship.
এটা
dismiss for default হয়ে গেছে লিমিটেশনটা সিঙ্গেল বেঞ্চে
সেকেন্ড অ্যাপিল তোমার যদি অ্যাডমিশনটা কোথায় হবে সেটা তো আমরা
এই সবই ডিভিশন অর্ডার 41 স্টেজে ডিসমিস হয়ে গেছে
অর্ডার 41 স্টেজে ডিসমিসড হয়েছিল
মাত্র সেকশন 5টা হবে সিঙ্গেল বেঞ্চে ডিলে কন্ট্রোলের এই তো ডিসমিস ফর ডিফল্ট ডিভিশন বেঞ্চেই হয়েছে তাহলে ডিভিশন বেঞ্চকে রেস্টোর করতে হবে
affidavit of service filed in court today be kept with the records. Stop. In spite of service, the respondents have not appeared. Paragraph, this is an application. It is the affidavit. It is the restoration application to the application for restoration of SAT such and such and the connected application which were dismissed for default on blank. So paragraph, having heard learned counsel for the petitioner, we are satisfied with the explanation furnished for absence of learned advocate for the petitioner on the day the matter was dismissed for default. Paragraph, accordingly, the order dated such and such is recalled. Stop, sat such and such and can such and such are restored to their original files and numbers. Next, can such and such is disposed of, can 4 is disposed of. Paragraph, let the appeal and the connected application be listed under the appropriate heading. Thursday, Thursday.
Lordship, kindly fix the matter on Monday.
Next Monday.
Monday,
If there is a caveat, you please serve, okay?
Yes, your Lordship.
My lord, for the petitioner, matter may be placed over next week.
Next week?
Next week, my lord.
Not this week. Hey, execution, Devajyoti. On the prayer made on behalf of the appellant. $74. Not today.
76.
If this matter be taken over Thursday, man. Grateful.
On the prayer, on the joint prayer made by learned advocates for the parties, let this matter stand adjourned till Thursday date.
Grateful.
77.
The 77 below, there is a delay for filing this application. Due to client illness, section 5 is not filed with them. So kindly fix next week, in the meantime, I will file the application for consideration.
Learned advocate for the, it is 77.
77.
Learned advocate for the appellants
Yeah,
says that there's a delay in filing this appeal. Stop. He prays for time to file an application for condonation of delay. Paragraph lists this matter once again on next Monday, though. Stop. If in the meantime, any application is filed, comma, let the same be also listed along with the appeal. Stop. Service of such application should also be effected on the respondents.
Service.
78. 79. 80.
My lordship, item number 80, my lordship. My lordship, am I audible, my lordship?
Are you appearing in person?
My lordship, my father is the appellant. He is appearing in person. He is unable to come in a court today. And for my mother's illness, this 2 weeks he is busy with her, my lordship. So I am praying for next circuit, my lordship, this matter.
এই কিভাবে appearance record করবে জানি না। এই তো বলছি appellant তো in person appear করছে তার মেয়ে। কিছু আছে? Are you appearing for the state in this matter?
In this case, there was a direction to start a case on the basis of their affair. For my instruction that the case has been already
Start a case.
the basis of their affair.
This is of their?
Affair lodged by the petition. Appellate.
Appellant appears in person. Effect contract. Report where's your report? You were directed to file a report.
That report.
Yes, file it.
Next circuit করতে বলছেন? Next circuit. রাখবো তাই next circuit করতে
order. By an order dated
online, if I may just add.
Who are you?
My lord, I am for the concerned private respondent, my lord, this one number 7. Against me, my lord, investigation has been directed, which I agreed. It's a matter which requires to be, my lord, investigated. FIR has been lodged, investigation is going. So, my lord, the grievances of the petitioner has been substantially redressed. Now, my lord, whether your lordship will keep this appeal pending? my lord,
Yes,
that's,
because we want the report to be filed.
report to be filed.
That's it. On the prayer made on behalf of the state, comma, time to file report in terms of the order dated September 27, 2024, comma, is extended by 3 days from date. Stop. Let this matter be listed again on Friday date.
My lordship, my father will not able to
Next.
come. My lordship.
Next.
My lordship, my father.
Your Lordship, I appear for the appellants. I was humbly praying that the matter could be taken up on 13th, Your Lordship. Your Lordship, am I audible? I'm appearing for the
Lordship,
appellants, Your
I'm
Lordship.
for 82. Learned AG is there.
Oh. Yes.
Lord, in the item number 82.
Yes, Mr. Advocate.
But these appeals, according to me, is no more surviving. Because, my lord, the order,
Yes.
the appeal is, my lord, against an order of 9th of April 2024. My lord, this was carried to appeal, my lord, in the principal bench, my lord, the Honorable Appeal Court. Hearing this appeal was pleased not to, my lord, pass any order. Finally, my lord, the matter had travelled to the Supreme Court. My learned junior is there, my lord. My learned junior will hand up a copy of the order of the Honorable Apex Court.
No, so therefore, Mr. Dotto, state's appeal was dismissed. State's appeal before the division bench?
Lordship.
Was
Stay was not granted or appeal was pending. Stay was not granted, appeal was pending.
Oh, stay was not granted.
19th of April, 2024. If your Lordship may kindly have a look to the order from your Lordship's files. Paras 9 and 10, my lord, of the Supreme Court order.
Yes, therefore nothing survives of the appeal. Absolutely
Yes,
right.
yes.
We'll dispose of the appeal, sir.
Yes.
Sure.
Kindly record that and dispose of it.
Yes. These two appeals, actually, were filed by the state of West Bengal and its concerned department, assailing an order dated April 9, 2024, passed by a learned single judge of our court in WPA 1089 of 2023. Stop. By that order, the learned judge directed the Central Bureau of Investigation, (CBI), to make preliminary examination and/or analysis of the allegations made in the concerned letters and submit a report regarding the outcome of such exercise. Stop. Paragraph. In the two appeals, stay applications were taken out by the appellants. Stop. By an order dated April 19, 2024, a coordinate bench refused to pass any interim order and directed exchange of affidavits. Stop. That order of the division bench was carried to the Honorable Supreme Court by the state of West Bengal. Stop. By an order dated September 24, 2024, the Honorable Supreme Court allowed the state's appeal Stop. The order of the division bench dated April 19, 2024, as also the order of the learned single judge dated April 9, 2024, were quashed by the Honorable Supreme Court. Stop. The learned single judge of this court was directed to decide the writ petition in accordance with law. Stop. Paragraph. In view of the aforesaid, nothing survives in these two appeals. Stop. The appeals and the connected applications are accordingly disposed of. Yes, Mr. Dotto? Freeze করে গেছে ফ্রেমটা।
I'm grateful. Yes,
Very.
please. I'm grateful.
You are absolutely fine now?
Yes, yes.
Good. You look good.
But Justice Banerjee did not keep your promise.
I will once I am back. Once I am back.
Very good. Very good. I'm grateful.
দুটো অ্যাপিল, তিনটে চারটে অ্যাপ্লিকেশন।
Item number 84.
The next before I am asking for the appellant petitioner. This is a matter not relating to the compassionate appointment. The father of the petitioner would.
Service. ফাইলটা আছে? It appeared. Today is the first day of the circuit. You know who appeared for the state? Miss Bedoshruti Bose and Mr. Hirok Bormon.
Even then, there's a direction to serve the copy to the Thakur Conjanan Mohila Mahabudala.
Yes, that is the school authority, college authority.
I prayed for the compassionate appointment in time. My father died. Within 1 month, I applied for the compassionate appointment. When the college was affiliated under North Bengal University, and there was a scheme for compassionate appointment. And my prayer was also forwarded by the college authority. That is also there. Even then, they were silent about my prayer. I filed a repetition.
Madam, why are you arguing the case? The other side is not here. Where is your affidavit of service showing service on respondents 3, 4, 5? Hey, কোথায় দেখো না? কোথায় affidavit of service দেখো না? By the last order? No, state appeared. But you were directed to serve on the, yes, where is the evidence of that? Sir?
One second, answer.
No, নেই, no. এই লেখো তো। by the last order dated September 27, 2024, a coordinate bench had directed the appellant to serve the non-appearing respondents and file affidavit of service on the next date. Stop. Paragraph learned advocate for the appellant says that although service was effected, there is no evidence thereof. Stop. She says that she will serve again and file affidavit of service. Yes, correct. Non-appearing respondent. Huh? Paragraph. Monday.
Lordship, I'm praying for 1 day accommodation.
Not today.
On behalf of the private respondent, I am praying 1 day's accommodation tomorrow. I'll stay after the vacation. Not get ready properly in all the matters.
There was a direction upon the Pradhan to file a report, my lord.
I'm for the Pradhan and
Okay.
report is here.
Everybody is here. Come back tomorrow.
87. Item number 87.
Lordship, praying for not today.
88.
My lord, I'm for the petitioner. Matter may be fixing next week.
On the prayer made, huh?
Petitioner. 89.
Deeply honored.
89. 90. 91. 92.
92, 93, I am for the appellant, which I was trying to mention for upgradation in the morning. There's some defects which is showing in the column. I'll cure the defects. Kindly takes it up tomorrow.
Tomorrow. On the prayer made on behalf of the appellant, let this matter stand adjourned and be listed again on Calcutta date thou.
And if
You are for whom?
Subject to your lordship's convenience, if this can be taken up on Wednesday, I am led by Mr. Charan Gupta. He intends to appear.
Listed again তাহলে কালকে না পরশু দিনের ডেটটা দাও. So in the meantime, let the defect noted by the stamp reporter be cured.
Grateful.
Same order in 92 and 93.
92 and 93.
94. That's it. 94. 95.
95, your lordship, the service has not been affected. It has been dispatched. Your lordship, kindly make it on a Wednesday, your lordship.
Wednesday.
Lordship.
97. 96.
Pardon, your lordship. 95.
Almost a 326 case. Yes, what's
Pardon, your lordship. 95 and 96, both the matters are similar matters. Your lordship, same prayer. Kindly fix it.
Wednesday.
97.
I'll be making similar to this matter which can also.
Wednesday.
Since there was some defect, the file was checked, Malad granted the liberty to go through the file. Kindly takes it on Wednesday.
Wednesday রাখো মঙ্গলে উষা বুধে পা বলে না সবাই বুধবার.
Grateful, Lordship.
99. 100. 102. 103. 104. 105. 106.
My lord, it is my appeal. Will it be Lordship's convenience to take it up on Wednesday? My
It's
lord?
an application. What application? 106.
My lord, I could not make myself.
No, 100
We
is
missed the
scan
list,
one is
my lord.
there.
I'll be candid, my lord. We missed the list, my lord. Kindly takes it up on Wednesday.
Thursday.
Thursday is your lordship.
Too many matters on Wednesday.
As your lordship.
Thursday.
107.
Sir, I am for the appellant. On this one, there is a defect in the memo of appeal probably. I have to check and correct.
They need to remove the defect. They have the
Thursday.
Lordship.
Let this matter be listed once again on Thursday. Date thou stop in the meantime. Let the defect as noted by the stamp reporter be removed.
108. 109.
109, I am praying for not to.
110.
Sir, I am for the appellant in this matter. Kindly allow me. Lordship,
What application is this? Can one?
Lordship, this is the application for appropriate orders. All the documents I could not attach.
Your petition was dismissed.
No, Lordship,
Oh.
this is not writ petition, Lordship. This is appeal is directed against the order of injunction passed by the order of status quo passed by the Learned Civil the Senior Division Alipurduar.
Have you
In
served?
a suit for specific performance of contract.
Have you served?
Yes, Lordship. Service has been complete.
It was an ad interim order,
No, Lordship. This is
contested order.
Contested order. Lordship, it is served and it is from.
Where's your affidavit of service?
Affidavit of service. You kindly make it not to.
Chalo.
111. 112. 113. 114. 115.
For the appellant, Mala, there are 33 respondents, Mala. It will take time. Can it be, Mala, for the next circuit?
On the prayer made on behalf of the appellant, comma, let this matter stand adjourned and be placed before the next available circuit bench.
16.
What is this application for? Two applications.
Application, can one, maybe not this, actually I have got the order in can two, which I wait for. Injunction, I have got, actually, order against the husband has been passed, not the landlord. For a period of 8 weeks, so that will come again on 7th only. And Lordship, formal admission order is required in this matter. Which has not been passed on.
You are the wife. You have obtained an order against the husband restraining him from marrying
Right.
for 8 weeks.
For 8 weeks.
That 8 weeks period will expire when? So what do you want today?
Formal admission order is required and the order passed by Honorable Justice that has to be extended to disposal of the everybody.
The file to now? File to pay?
My lord, I'm for the open.
You are for?
It's out of station address. So, not to, and it's more
Yes, so I don't not today চাইছি.
There is come more. 117.
I am for the appellant. In this matter, original decree was not attached with the memo of appeal. And due to intervention of this honorable court during the last circuit, the decree was prepared by the lower court bill. And I have to obtain the certificate and kindly make it not this week, Lordship.
On the prayer made on behalf of the appellant, let this matter stand adjourned for the week and be listed again on Monday.
118. 119.
118, Lordship. I am for the appellant.
118.
18, Lordship.
Yes.
And there is a direction on the respondent to file affidavit in opposition to my CAN application for limitation, condonation of delay.
Not filed.
Not filed and not served, and there is not present.
Who do you know the learned advocate
Yes.
appearing? Talk to him or her. We'll just say not today, find out.
Yes.
119.
For the appeal, there is a defect, lordship, I don't know. The defect.
Very well. Friday, in the meantime, remove the
I'll
defect.
check the-
Check. Let this matter on the request made by learned advocate for the appellant. Let this matter stand adjourned and be listed again on Friday, date thou. Stop in the meantime, let the defect noted by the stamp reporter be cured. Okay, ফাইলটা আর কি ওনাকে দেখতে দিও পরে।
120. Now the 120. 121. 22. 123. 124.
124, my lord, kindly fixed on, my lord, on 13 November. In this matter, Mr. Taran Pandit is appearing for the appellate.
Mr.
Taran Pandit. So, my lord, he will.
That is the penultimate day. We'll keep it, but we don't know how long, how far we'll be able to take it up. On the request made on behalf of the appellants, let this matter, appellant actor, yes, stand adjourned and be listed again on November 13.
125. 126.
But he's under some personal difficulty. It will have to be taken about Monday, my lord.
On
This
the
is
request,
second appeal, my lord.
on the request made on behalf of the appellant. Hmm?
And 128. 129.
129, I am asking for the appellant order 41 upon the order, lordship, I have not read, lordship, kindly give it on Friday, lordship.
Friday.
130.
Lordship, item number 130, I am praying for 1 day's accommodation, Lordship.
Not
Kindly
today.
fix it tomorrow. Grateful, Lordship.
132. 133.
I am for the petition. Oh, acha, the call.
Sorry, lordship, I missed, my lord, 131. Lordship, same prayer order 41, amount order, lordship, Monday, lordship.
Monday.
133.
Hello, in this matter, Mr. Pritam Das, I have been led by Mr. Pritam Das, and due to some urgency, he has to leave the court premises. So if the matter can be taken up tomorrow.
No,
No.
133.
33. I am.
Not today.
If you are.
134. 135. 136. 137.
Lordship, item 137, I am praying for 1 day accommodation, Lordship.
Appearing for?
Lordship, I am appearing on behalf of the petitioner. My senior, Mr. Ratan Manik, is appearing on behalf of the petitioner, Lordship.
Not today.
I'm good.
38.
Lordship, I am for the appellant in this matter, Lordship. And there is a direction for preparing paper book, and the opposite party supplied a voluminous document. It could not be prepared.
I'll tell you, Lordship, what has happened.
No, you have not been able to prepare the paper book. You want extension of time.
Lordship.
This is what? This is a WPLRT. We'll extend the time, Mr. Basu. We don't want to hear on merits. Let him file. How long you want?
Lordship, 1 week time will be sufficient, and it is almost ready.
1 week. Time to file paper book in terms of earlier order of this court is extended by a week from date. Stop. Let a copy of the paper book be made available to learned advocate for the, let copies karo, a copy na. Learned advocates for the respondents. Paragraph, list this matter once again on Tuesday week kore dao. Date ta debe.
Let me do one more thing. This matter is perhaps, not I'm not on that, but just informing you, but perhaps appearing wrongly under the headed motion. There is an order, speaking order of the division bench prior, fixing the matter of the hearing. So that is what I was.
The hearing the other.
Problem.
My lords, I am on behalf of the petition in the item number 139. My lords, am I audible?
But it's 139. Are you appearing in 139?
Yes, my lords, in 139, in behalf of the petitioner.
কি বলছে 169 বলছেন?
139, my lords.
Yes.
139, my lords.
Yes, yes, we can hear you. Tell us.
I'm on behalf of the petitioner. In order dated 24th 9, there were some defects which were cited by the honorable court, which have been removed. I pray for 1-day accommodation. my lords.
Not today.
140.
Yes, Lordship. I on with the petitioner, Lordship. I paying for 1-day accommodation, Lordship.
Not today.
41.
Lordship, may I one pair, Lordship? In item number 128, Lordship. Second appeal, there is a delay, Lordship.
Yes.
Lordship, it goes to the single bench, Lordship. There is a delay, Lordship. Second appeal, Lordship.
This can one is what?
Condemnation of delay, Lordship.
Condemnation.
No, question is, in can one is condemnation of delay in filing what? Restoration application?
No, no.
Or the main
Lordship.
appeal?
Main application, Lordship. Second
So,
appeal.
main appeal is dismissed for default.
No, Lordship. This is
No, no.
second appeal, Lordship.
Second appeal with condemnation.
Okay, so condemnation has to be heard by.
Yes, Lordship.
এটাকে কি অর্ডার দিতে হবে?
Yes,
Order, let it go to the single bench.
This is a second appeal along with an application for condonation of delay in filing the appeal. Stop. The condonation application has to be heard by a learned single judge. Paragraph, let this matter be stand released from our list and be placed before the appropriate court.
Grateful, Lordship.
Just indicate with
ওটা 128 এ হলো, হ্যাঁ।
138, which your lordship has kindly fixed it on Tuesday week. That day I am in extreme difficulty to present myself before your lordship. Your lordship kindly fix it Friday. It's
Which Friday?
Definitely.
Next Friday, Friday week is a holiday.
Thursday is the last working date, so far this circuit is concerned.
We'll place it before the next circuit then. No problem at all. এই কি লিখেছি বলো তো?
130.
Other side, you are appearing?
Yes, sir.
So next circuit?
হ্যাঁ। না বাই উইক করো না, তাহলে নেক্সট সার্কিটে যাচ্ছি জানো, টিল একদম নেক্সট থার্সডে করে দাও, থার্সডে উইক। হুম, তবে this matter once again before the next available circuit day.
No, my learned friend has just now indicated to which I also indulging in it. That is Monday, the coming Monday, my lord. He will be ready with the paperwork. If the lordship is kind enough to take it up on Monday, the coming Monday, he needs only 4-5 days to do that, so that we can get audience. That's Monday.
No, is there any urgency?
No,
You can't wait till the next
respondent,
circuit.
my lord.
Next
No, you can wait till the next circuit.
next circuit.
141. 142. 143. 143. 144. 144.
140.
No, no.
State now, where's the respondent?
Respondent is not responding.
What is this, matrimonial?
Matrimonial.
No, not responding meaning he never appeared.
In the trial court, initially she appeared and filed a written statement for contesting the suit, and thereafter she didn't turn up. Thereafter
Your
the
suit was
matter-
dismissed.
No, I am for the husband petitioner in the court below.
Your
And,
suit was dismissed.
Suit was dismissed.
What I'm saying.
Yes, Lordship. Suit was dismissed.
So service is complete. Notice,
Yes,
notice of appeal.
completed paper book has already been filed.
Notice of appeal, sir.
এটা তো এখন হিয়ারিং হবে।
Notice of appeal কিন্তু both side ছাড়া এটা hearing করাও মুশকিল, এটা matrimonial service আবার করুক।
Sir, serve again. This can't be heard ex parte. Final hearing of appeal.
Finally.
Yeah, serve again. This is the husband's appeal against a judgment and decree of the learned trial court dismissing his suit, praying for dissolution of marriage with the respondent. Stop. We are told that paper books have been filed. Filed. Stop. Nobody appears for the respondent today. Paragraph. Let a notice be served on the respondent and oblique or her learned advocate, intimating that this.
I intimated the learned advocate on the next circuit also on the request of this honorable court. He also stated that his client is not contacting with him.
No, do it in writing. Where is the proof?
Lordship.
You will know.
Previously service affidavit is there.
Intimating that this matter will be listed again on Friday, the Monday date, the Monday. Or if a Friday date, the Friday. Stop. If nobody appears for the respondent, comma, the matter may be proceeded with ex parte.
Deep Lord.
145, Your Lordship, I'm praying for Friday to be fixed, Your Lordship. I'm led by Mr. Nilanjan Bhattacharya, Your Lordship. So on his ground, Your Lordship, I'm praying for this matter.
How
to be
is he
fixed.
now?
He is doing better. He is still in.
Attending court.
No, he has not, Your Lordship. He would be appearing virtually, Your Lordship.
Friday.
Friday.
146,
Yes, Your Lordship.
147, 148, 149.
I put the state.
ইউলো এই তো নেই তুমি উঠে দাঁড়ালে তুমি আর্গু করবে না
150,
স্টেটই তো নেই
151, 152, 153,
For the private response.
154.
Your Lordship, in item number 154, kindly Your Lordship takes the matter on 8th of November. Your Lordship, my senior, Mr. Bodhan Bhattacharya, will appear physically. He's coming from Kolkata.
It's on a Friday.
On the prayer made on behalf of the appellant, let this matter be listed again on Vijabul Sikura.
155, 156.
For the petitioner, my lord. The matter may be fixed
Hey.
next week.
যেটা ফ্রাইডে ফিক্সড হলো, যেটা 154 স্টেট আদার সাইড ছিল, 154 তো নয়, হ্যাঁ 154 কোথায় চলে গেল না, কোথায় আছে 154 দূর বাবা,
এই তো ছিল, এই বললো।
ইনি তো, your senior will be coming from Kolkata, you said. Very well, intimate your other side that this will be listed on Friday again.
156.
My lord, I'm for the petitioner. Matter may be fixed next week, my lord.
On the prayer made on behalf of the appellant, let this matter be adjourned for the week.
157.
1. For the respondent now.
158. 159.
For the appellants in item numbers 159 to 162, my lord, there was a direction to file paper books. Sometimes seeking extension of time to.
How long?
My lord, 1 week.
On the prayer made on behalf of the appellants,
Appellants.
comma, time to file paper books is extended by a week from date. Stop. List this matter once again on Tuesday week করে দাও.
Grateful, lordship.
Item number 163. 164.
এই 159 থেকে 162 সেপারেট অর্ডার্স করবে.
165. 167. 168.
Criminal appeal.
169, 170, 171, 172, 173, 174, 175.
175, my lord, I am for the appellant. I pray for not this week. my lord.
On the prayer on behalf of the appellant, huh? Let this matter stand adjourned for the week.
176, 177, 178, 179, 180, 181, 182, 183, 185, 186, 187, 188.
Lordship, 188, 189, 190 and 191. Can we pick this matter on next week?
Same order.
One 192, 193, 195, and 196.
Mr. Advocate General, now nobody can make in a grievance.
That would be.
Yes. So what do you suggest? We keep the list like this?
Because now I know that this criminal appeal, they intend to take some time to prepare themselves.
এরকমই থাকবে লিস্টে কালকে যা আছে।
So anyway, get yourself ready, all of it.
Yes, no, in the civil appeal, we are all ready.
Yes, civil.
Yes, we are ready. The 3 matters even is posted Wednesday because of some certain technical defects. We are ready.
Any matter where both sides are present? Yeah, you.
But in my 3 appeal, your lordships, your lordships, it's a similar matter more or less. One, your lordship, 13 days delay, and one, if there is an defects, your lordship, if your lordship may grant leave to correct your lordship.
Which matter?
88, 90 and 91, your lordship. In 89 is okay. In 90, your lordship, 13 days delay, your lordships. And item number 91, there is a one leave may be granted, your lordship, for correct the respondent's name.
Sir, 88, there's a delay, you say. নাই কোনটা বলছে?
13 days delay.
No, 90, there is no such remark as defective or something.
91, your lordship.
91.
Oh, 91, there is a
91
defective.
your lordship. No.
How soon can you cure the defect?
Only respondent number, name of the respondent number 7, your lordship, type of
91 লিখে দাও. Leave is granted to learned advocate on record for the petitioners to cure the defect. Stop. List this matter once again. কালকে date দিয়ে দাও. And in 90?
90, your lordship, 13 days delay. We have already served the copy to the learned advocates of the big petitioner, your lordship, Arijit Ghosh and Vikranaditya Ghosh.
Talk to him. We not today হয়েছে তো. Come tomorrow.
Lordship. Then only 91, your lordship.
Shall we go?
My lord,
Yes, Mr. Advocate. Shall we go? Oh, what to do? Now we have to correct the orders, sign them.
my lord, item number 102, my lord, others said it, I am for the appellant.
Yes.
And his, my lord, respondent, others said it, his respondent. My lord, this matter, my lord, is a dispute between the parties, a matrimonial dispute, my lord. I am praying for appeal against the order of the mat suit. So, my lord, they give some proposal for settlement, my lord. Going on, my lord.
Staying for.
Not this.
One day.
No, ওরা নিজেরাই Would you both agree to go before a mediator?
I need some instruction, my lord.
Take instruction. We'll keep it as to be mentioned. Tomorrow?
The day after tomorrow, my lord,
Day after tomorrow to be mentioned.
One indulgence, my lord, if my learned juniors have indicated with regards to item number 97, which has been posted on Wednesday, my lord.
Okay,
There is 2 pages, there is a mistake in while making a resignation, my lord. With the leave to your lordships, my lord, can I correct that?
correct.
2 pages only,
Correct.
numbering.
Correct.
That to that page is, well, 1 page is missing, can we incorporate that?
Do that.
97.
No formal order is required.
The post title page is of the lead petition, my lord, which has not been annexed. And numbering has been, that's why the misplace.
Very well.
Grateful. Lord. 97